Welcome to Booked, the bookstore education podcast brought to you by the American Booksellers Association. In this episode, we're digging into the ABA archive with a session presented during the Virtual Winter Institute in 2022, Unions 101 for Booksellers and Bookstores.
Hi, everyone. We are so happy to be together with everyone for Snow Days. Thank you all so much for joining us. And thank you for joining the Unions 101 session. I wanted to say a few words about why we planned this session, and then I'm going to hand off to Joy to get us started. We have heard from bookstore owners and booksellers who wanted to know more about unions. We heard from bookstore owners who wanted to know things like what happens if they're presented with union cards or what to expect from the unionization process. We've heard from booksellers who wanted to know more. They wanted to know what questions they should be asking and what the unionization process might look like for them. So we really wanted to create an informative, balanced session where everyone could learn more and ask questions. ABA currently has about 40 union bookstores as members, and in our conversations with some of them, the experiences have varied. We have had bookstore owners share with us that their union negotiation process has cost them over $100,000 and been very complicated. We've had others share with us that their union negotiation was very simple and pretty reasonable in terms of cost. We've had owners say that they were frustrated when they were unionized because they really wanted to be able to discuss things with their employees directly, and now they have to go through the union. We had other owners share with us that that structure had been very helpful to them. That same structure really facilitated communication with their employees. On the bookseller side, we heard from booksellers who were unionized, who liked having a collective bargaining voice. They appreciated more transparency around wages and in some cases had received higher wages as a result of unionization. We talked to other booksellers who were unionized who didn't think their rep was serving them well with their union, or who weren't so sure their union dues were worth it, or who were frustrated that once they were unionized, they couldn't go to an owner and have a conversation that they'd had in the past. So there's a lot to understand about unions generally and specifically. And we think that ABA's job is to help booksellers and bookstore owners be as informed as possible. And regardless of whether a store is unionized or not, we really want to focus our support on conversations about livable wage, dignity and flexibility for workers, and good communication between owners and workers, because we believe that those things are in everyone's best interest. So with that, I'm going to hand off to Joy to get us started.
Hi, everybody. This is how it's going to go. We have this brief introduction, then we're going to turn it over to Jon and Mark, who are going to spend 10 minutes really going over why are employees talking about unions, what are the pros and cons. Then we'll have 20 minutes on the unionization process. And as they have told us, they could spend hours on each of the topics within this. I mean, this could be, it could be a lifetime. And then we will do Q&A. And so now I'm going to tell you a little bit about our presenters, and just a little, because you can find their bios on the Snow Days website under featured speakers. Jon Hiatt is a labor lawyer with 47 years of experience. I'm sorry, Jon, I had to say it. It's magnificent, actually, and is currently counsel for International Lawyers Assisting Workers Network in Solidarity Center in Washington, D.C. Mark Reese, also impressive, is a lawyer for the employer side with 30 years of experience, and he is currently counsel for Littler Mendelson PC in New York. What impressed Allison and me about both of them is that they both really can speak well to both sides of the situation and absolutely understand the importance of workers' rights and owners' rights. And so without further ado, I'm going to turn it over to Jon and Mark. Thank you.
Thank you, Joy. Thank you, Allison. And hello, everybody. Rarely, when I do get a chance to speak, and I'm introduced, am I the junior speaker by 17 years, but to that extent I am, and I welcome the opportunity to discuss these very important issues with you and with Jon. So we're both going to start off on the same topic, but I'm going to start off on the pros and cons of unionization today and start off with why are employees unionizing? And there are, of course, the obvious reasons. People are dissatisfied with their wages. They may be dissatisfied with their benefits, such as health insurance or paid time off or pension. They might be dissatisfied with their working conditions or their working environment. There's issues of job security that are a byproduct of perhaps layoffs at a store. And then, of course, there's inconsistent application by management of policies and procedures. In other words, not applying these things equally to all employees. But there are also less obvious reasons. And those are a perceived lack of dignity, appreciation, or respect from management, poor leadership or poor attitude by management, poor communication by management to its workers. And throughout my career, the vast majority of union organizing attempts came from the first group, the obvious reasons group. In the past 2 or 3 years, such union organizing efforts have come increasingly from the second group, and employees who still are concerned about wages and benefits seem just as concerned about the issues of respect and appreciation. Clearly, the impact COVID has had in the workplace has contributed to a focus on some of these issues like safety and appreciation and respect, but they were present even before the pandemic started. So what are the pros and cons of being a unionized workforce? For this part of the presentation, I'm going to stick to a very general overview. The specific pros and cons from both the employer and employee perspectives often depend on a variety of factors, which may be based on the individual employer, the employees, the union, where the store is located, and a variety of other factors. So how do both sides benefit from a union relationship? Well, one thing that jumps right out is the standardization of things. With unionization, wages, benefits, time off, work rules, seniority issues, or things like promotions or transfers or layoffs, will now be in one place, the union contract, which has presumably been agreed to by the parties during the course of their negotiations. So if the employer and the employee want to know what a particular employee should be paid based on the employee's position and the date of hire, they can simply look in the union contract. What's next year's raise going to look like? It's in the contract. If there's a job opening and there's a question of how to fill that position, there will likely be language in the contract dealing with that issue. So there's a certain level of consistency and stability that comes from having all of these items contained in one document that was mutually agreed to by the parties. Another benefit of unionization is that employee workplace issues will now be dealt with in a more defined manner. Most union contracts have a grievance procedure, which spells out the process by which employee issues of complaints are handled and designates who the specific individuals are from both the company and the union who will address these issues. The process allows employees to have a more formal system in which to challenge workplace issues and an advocate, the union, to represent them. A third benefit is more of a shared voice in the workplace. Typically, the union contract will contain certain policies that are negotiated by the parties or will hold management to a standard of having to make reasonable rules and regulations. This creates a sense of a more collaborative effort by both sides in the shaping of policies that govern the workplace, and it affords both parties the ability to have a say in promoting a positive work environment. And finally, there's an issue of defined cost. And by that, I mean union contracts are typically for multiple years. That means employers have the benefit or the ability to know their labor costs for an extended period of time. That's often viewed as a positive when employers are doing their budgets, as they, again, have an advanced look at what their labor costs are going to be going forward. And employees have the same luxury. For the term of the contract, they know what the rate of pay is for each position, the amount of any annual wage increase, the amount of paid time off they can take each year, insurance costs, and things like that. So what are some of the cons? Well, I just got finished explaining the pros to you. My answer on the cons is there's a great deal of overlap between the pros and the cons. Remember when I said the standardization of things is a positive thing for both sides? Well, to some extent, it could also be a negative. A union contract will spell out the way that employees are paid or how they get promoted. And that means that if the employer wants to pay a particular employee or a certain position more money, or say raise the starting rate for a position because they're having trouble hiring, they can't do so without the mutual consent of the union, as the rates were negotiated and set forth in the contract. If an employee feels like he or she individually is worth more money and wants to go to the employer and ask for a raise during the contract term, they likely can't do this without an agreement from the union. And the same thing with other issues like promotion, for example. If the contract says a promotion will be awarded by seniority, the employer just can't pick who they feel is the most qualified for the position. And likewise, an employee who might feel they are the most qualified person but happen to be junior to some other people who apply for the position may not get the position they want. So in essence, the positive aspect of the employer and the union having a contract whose terms include specific pay, benefits, and working conditions also carries with it the inflexibility that comes with having such defined terms. And with that, I will turn it over to Jon.
Thanks a lot, Mark, and thank you, ABA, and all of you who are attending. For those of you who were hoping that were expecting some fireworks between Mark and myself on some of these issues, you're probably going to be somewhat disappointed, because I think an awful lot of what I intend to talk about here is not at all different from what Mark has just gone through. There is, let me just start with kind of this phenomenon that we're seeing not only in the bookstore sector, but in a number of sectors in particular today, and in general, with a wave of organizing and unionization that seems to be happening quite spontaneously. In many cases, it's not because unions are out there organizing the workers, it's workers themselves who are initiating. The reasons, as Mark said, vary. As he gave several examples, and I think it's worth stressing that it's by no means all about economics. I don't think it has ever been all about economics, but Mark is absolutely right. I think it's much less so even today than it has been, and that's somewhat ironic given how precarious workers' economic situations are in many cases today. But really, what some may call dignity and respect, I think of as worker voice. What is motivating people in so many places right now is just wanting to have more voice, more influence, more ability to discuss, to have input with the employer on a variety of issues. The Democratic National Committee recently was organized by the Service Employees International Union. One of the first things they said at the beginning of the organizing campaign was, the union said to the DNC, we just want you to know that your employees are not particularly unhappy with you, with the people running the DNC, with the DNC itself. To the contrary, they like working here, and they have ideas about how to provide for more job security, career ladders, more opportunities to advance. So this was, whether this was true or not, it was a very smart thing to say. The employer, I think, was relieved about that, and so far all signs are that is what has been motivating the employees there. There have been some very interesting examples in journalism. I attended a panel where a sort of old school employee from a longtime newspaper, a union rep, was talking about what was motivating the employees there in their bargaining. They've been organized for years and years. And he was saying that the motivation is typically wages and pensions and health insurance. And then there was a new worker, a new steward, a union organizer, employee organizer at Gawker, which had just organized. And he was asked, why do your employees, your online, this online news media group of employees, why are they organizing? And they said, well, yeah, we care obviously about wages and health insurance and so on. But really what's motivating us is having more say over editorial content, over the prioritization of what articles we can cover, what direction things are going, et cetera. And they recognize that under the law, they don't have the right to bargain over traditional management right issues, but they still, with a union, have the ability to sit down and give input. And that was motivating them. You've seen a lot of nurse organizing recently, and a lot of that is over training and staff ratios, staff-patient ratios. You've seen the graduate assistants at a lot of universities organizing. That's over, in many cases, that's been over sexual harassment issues and trying to have better sexual harassment policies. I think one advantage that you all have in the bookstore sector is that you've got a largely highly educated group of employees who are very committed and loyal to the work and to the store. I mean, I'm sure not always, but in many cases that's the case. They don't want to put their store out of business any more than you do. And so, what's motivating them often is not huge wage increases, but rather the kind of grievance procedure that Mark was talking about, scheduling issues, having a labor management committee so that on an ad hoc basis, they can deal with new issues that arise, DEI issues, and so on. While sometimes the employees do seek an established union to represent them, whether they do that or they stay independent, it's just the employees themselves. At its core, the union is the employees themselves. It's them coming together to try to find consensus about what the priority issues or the priority concerns are, trying to rationalize the way in which those concerns are raised and discussed with the employer, and then institutionalizing the agreed upon terms in a clear, enforceable contract, as Mark was describing, not all that different in its format from an employer's own handbook. So bear in mind where a majority of the employees do decide to have a union, the employer's legal obligation is to sit down and bargain in good faith, but not to agree to any specific term. Neither side has an obligation to agree to a specific term. The obligation is to sit down and try to reach an agreement, to listen to the other side, and to compromise as best they can. So finally, just a few pros and cons that I would add and that again overlap. Unlike with legislation, the key value to collective bargaining agreements is that they are tailored to particular workplaces. Mark made an issue about this as well. And I don't really, I think, yes, it can be a con, not a pro, that standardization sometimes makes it difficult to address individual concerns that vary from what's in the contract, but it doesn't have to be that the contract is inflexible. You can have wage rates and still provide for merit increases. You can have standard hours, but still provide in the contract for hours that vary depending on certain circumstances. So you can take all of that into account. And when issues arise that neither side had foreseen because of changing circumstances, there's nothing that stops the parties from sitting down and bargaining addenda or bargaining variations to the contract. I think it's worth also stressing, I know in Indiana, there was a hospital administrator who'd recently become unionized, and they were dreading what this would mean. And about a year later, they said, God, this is the best thing that's happened to us. We have so many individual complaints that used to come to us. Now they go through the union. And the ones that really have substance come to us eventually. The sort of fringe ones get disposed of before we even have to deal with them. So I think that the sort of informal and inexpensive way of resolving complaints and disputes is definitely a major advantage for both sides. Management rights, typically in contracts, still are allowed. There's typically a management rights clause that makes it clear that sort of the core managerial right to run the enterprise the way they see fit, the bookstore in the direction that they want to go, that still is totally up to them. They can still talk to staff directly. So yes, there is this standardization, but it comes with the flexibility that for the most part, especially when the relationship evolves into a good, decent, mature relationship, it doesn't at all preclude the employer from being able to talk to staff directly and from being able to run on a day-to-day basis the way they have in the past. Finally, the predictability that Mark was stressing and labor peace, it's almost universal that a contract has a no strike, no lockout clause in it, so that when there are issues, even if they're very heated issues, they have to get resolved through the grievance procedure, typically with an arbitration clause at the end, way cheaper than going to court. and both individual complaints and group complaints get funneled that way. So I'll stop there, and I think we're going to go next to process. And I guess since Mark started that first section, I'm going to start the second one, and then he'll pick up from where I leave off. So let me talk a little bit about this is more the nuts and bolts part of this. And we are, as Joy and Allison both said, going to leave plenty of time after this next section so that we can field questions that you may have about any of this or anything else that we haven't touched upon in this very short time. So let me just start. What I want to cover a little bit is about how does the unionization process get started, by whom, what's the difference between voluntary recognition and NLRB elections, what are the unit issues, that is deciding who's in the unit and who's not, and then finally the bargaining process. If a union is brought in, what is involved in the contract bargaining. So how and by whom? I mean, there is this myth that a union is just a bunch of outsiders. And again, as we both mentioned in the last section here, it is extremely rare, especially with union density being as low as it is today, and there being so few union organizers that are out there organizing the many, many workers that are interested in organizing, that unionization starts because some outside union comes in and tries to organize the workers. Almost always, it's the workers themselves, some of the workers, obviously rarely all the workers, that start and seek to unionize. Sometimes they go out and get the help, the experience, the expertise, the resources from an outside union, and sometimes they stay independent, as I said before. There are two ways that the employees will have the right to get to have a union. One is through what's called voluntary recognition, and the other is for an NLRB election. Voluntary recognition is where the employees say to the employer, we believe we have a majority of the workforce, a majority, 50% plus one, who have signed the cards, or signed a petition, or signed in some way indicating their desire to have a union. And the parties then, if the employer agrees to test the majority status voluntarily without going through an NLRB election, then the parties agree on a third party, a neutral third party, like some respected politician or some respected public official, some academic, some arbitrator, some judge, who can come in and just who will look at the cards that the union has, match them against the workforce that the employer provides. And if a majority have indeed said they want the union, then that the union is certified to represent those employees. The other way is to go to the NLRB and have an election, have the NLRB, the National Labor Relations Board, hold an election, and that is from the union's point of view, it's often a much longer, much more drawn out, much more contentious process, and therefore, normally, the employees ask the employer to voluntarily recognize. Again, voluntarily doesn't just mean, in fact, it's illegal for the employer to recognize the union unless they can show through a third party neutral that a majority have said they want the union. But so at what point do the employees raise this with the employer? And that varies a lot. Sometimes, as soon as they get started, they'll let the employer know that some of them are trying to organize their fellow employees and that they want to have a union. Other times the employer hears about it before the union has officially gone to them. Normally, the employees ask the employer to stay neutral, but it is up to the employer, as I'm sure Mark will be discussing, whether or not to stay neutral or to actually advocate against the union. Even if the employer advocates, there are very strict ground rules that apply to both sides that that protect against interference, that protect against threats, that protect against favoring employees who are either pro or con on the basis of their union activity. So from the union's point of view and from many progressive employers' point of view these days, the ideal is to say right from the get-go, we're going to stay out of this. It's up to the employees to decide. That's what the Democratic National Committee just did when SEIU organized them. They sent a letter around saying and telling their own supervisors, stay out of this. This is up to the employees to decide. Now, who is the workforce for unionization purposes? It's what's called the bargaining unit. And that is typically the employees, all the employees in the workplace, minus supervisors, managers, confidential employees, or temporary employees. There are various categories which by law are not permitted to be part of the bargaining unit. Sometimes that's easy to know who's a supervisor, who's confidential, who's a manager. Sometimes it's much more borderline. And one advantage of doing the voluntary recognition process is that there the parties can sit down and try to agree among themselves who's in and who's out. And there can be a little bit of, trading off based on really where does it make sense to have people be in the unit? Are the back of the house people or the special events people who only come in periodically? Does the union really want them even if they're entitled to them? That kind of thing. So that's what the bargaining unit is. If you go to an NLRB election, the NLRB will decide. Both parties will say who they think should be in or out, but it'll be the NLRB that would make the final decision there. Finally, on the bargaining process, if the union, either by voluntary recognition or by an NLRB election, proves that they have 50% plus one after this campaign is completed, and it can take anywhere from days to weeks to months. But with voluntary recognition, it's typically much quicker. Once it's decided, if the union does have a majority, they get certified, and that means that they have the right then to bargain for a contract, to bargain for a collective bargaining agreement, which, as I said before, is coming together. Both sides decide who are their respective representatives. They put together their proposals. Both sides can do that. This does not mean starting from scratch. The employer doesn't have to throw out all of its rules and regulations and handbook procedures. By no means. That the starting point is where the workplace is at that moment, and then the workers can decide what are our priorities, where do we want to bargain. And as I said before, the key here is neither side has the obligation to accept proposals from the other side. There is simply an obligation to sit down, bargain in good faith, and try to reach an agreement. I guess the last couple of things I would say is that both unions and employers might want to look at collective bargaining agreements of other bookstores. I know now there are a good number of bookstores around the country that have been unionized and more that are in the process. And many of the ones that have been unionized have either new or long-standing collective bargaining agreements, and it might be worth looking just to see what the kinds of issues are that typically get addressed there. And finally, in terms of the role of an outside union when there is an outside union, that too varies. You have usually the unions that are interested in representing bookstore employees are, if not unions that already represent bookstores, because there aren't a whole lot, to be very honest. There are unions who do have experience with retail workers of different kinds. Are they always the right ones to know what the employees want? Not at the beginning necessarily, but they learn also. They learn from the employees themselves, and they do bring experience and expertise and resources in terms of the unionization and the bargaining process. So anyway, more on that if people want to talk about it, but I think that's a good place to stop and turn it over to Mark.
Great. Thanks, John. With a very thorough overview on the process, I too won't be redundant, but we'll try to fill in some particular things that I'll focus on. John mentioned effectively three ways that the process can go, right? Voluntary recognition, an NLRB election where the employer stays neutral, or an NLRB election where the employee chooses to engage in some sort of campaign to try to dissuade the employees from joining a union. But within that third universe, which is what I'm going to focus on, and as John mentioned, there are some very strict rules of what an employer can and cannot do. And I'm going to cover them now. So what an employer can do is an employer can share facts. They can share facts about the particular union who's trying to organize the people, the employees. They could share particular facts about unions in general. Employers can also share opinion, why they feel that a union is or is not needed for employees at their particular work site. So they can give facts, they can give opinions. And the third sort of general basket of what an employer can do during that campaign process is they can give examples or personal experience. So if, for example, you have some members of management who happen to be in a union, and many times that's the case. People came out of a union and went into management. Management personnel is, allowed to talk to employees during this period about their own personal experiences, good or bad. But there is also a list, and perhaps a slightly longer list, of things that employers cannot do during this process. And just the most common acronym is TIPS, TIPS, which is how people tend to remember what they can't do during this process, or employers can't do. And TIPS is the following. The T stands for threats. So employers can't threaten employees because of their support for a union. The I stands for interrogation, in which case it's illegal for employers to question employees about what they think of the union, what fellow employees think of the union, who's favoring the union, who's not, or specifically how any member is going to vote. It's also illegal to make promises, the P in the acronym TIPS. So the employer can't make promises or grant special favors or benefits in exchange for a vote for the company. And then finally, the S is surveillance. It's illegal to engage in any kind of surveillance or spying on any employees engaged in lawful union activity. So what are some examples of this unlawful activity during these campaigns? Threatening employees with a loss of job or benefits if they join or vote for a union. Threatening to close a store if employees select a union to represent them. Questioning employees about their union sympathies or activities and circumstances that may interfere with employees' right to unionize. Promising benefits to employees to discourage their union support. In other words, I'll give you better benefits, I'll give you more time off, I'll increase your pay if you don't join the union. Granting wage increases that are deliberately timed to discourage employees from forming or joining a union. And then finally, and by finally I mean final example, not necessarily that there certainly aren't others, would be something like transferring or laying off or terminating, assigning employees more difficult work tasks, or otherwise punishing them because they engaged in the union process. Now, as John said, there are certain rules that apply to employers and certain that apply to unions. And I don't say this strictly from being on the management side, but it's a little more lax on the union side to the extent that if a union did want to come in and promise that they're going to get everybody a $1 raise, they could conceivably do that. Although that type of statement is permitted under the law, whether that can actually be obtained obviously depends on whether A, they win the election, and B, whether they're able to secure that less or more during the bargaining process. So if the union wins the election, and as John said, it's a majority, but I think also another important distinction, it's a majority of those who show up to vote. So to just pick a silly example to make the point, if there are 100 people who would be covered in positions that the parties have agreed are the unit, and 10 people show up to vote, and 6 people vote for the union, so majority of the 10 that showed up to vote, that's a majority. It's not that you need 51, and if only 6 show up, or rather 10 show up, the union is already lost because they can't get a majority. It's the majority of people who show up to vote. And in the event that there is a tie, then that's not a majority and the employer would prevail, which has only happened to me once ever. In any event, as John mentioned, after if the union wins the election, what typically happens is they'll ask the company to sit down and begin contract negotiations. Now, that doesn't always happen right away because sometimes, and understandably, the union needs time to meet with the membership in order to formulate proposals, to select employees who are going to participate in the process. So sometimes it takes a little bit of time. Once negotiations begin, sometimes for a first contract, it takes a while to complete, although in my opinion, that's not necessarily a bad thing. The initial contract results in the parties discussing all the issues that go into a contract and can be time consuming. So John made I think a spot on point. The employer doesn't start from scratch, but you still need to have the conversation. So if you're going to maintain the status quo on a particular issue, you still need to have that conversation at the table so that it could be agreed upon and incorporated into the contract. So a lot of the issues that you discuss in a first contract are those that you would expect to, include, whether it's wages or benefits, paid time off, or the handling of job openings, promotions, layoffs, etc. But there are many other issues that may be raised by one party or the other during this process. And for that reason, the initial contract takes time, although it is important for both sides to be patient and thorough in the process. So at the end of that process, and after the parties are finished bargaining, hopefully they reach an agreement for a multiple year term, and we can, they could both go on their way from then and go back to, their relationship. And there's another side to this, which is what happens if the union doesn't get a majority. If the union doesn't get a majority in the election, then there's a 1-year bar for that union or for any other union to petition the employees of that store or company to become members of the union. After that 1-year period, then that union or any other union is free to file a petition or request voluntary recognition, provided they meet all the other criteria of the law. So that's what I wanted to sort of add to John's piece on the process.
That's great. Thank you both so much. It's a lot of good information. We do have questions in the chat, so we're going to jump right into them. There are a couple of categories of questions, which is helpful. We have several questions around size, so I'm going to read a couple of them to you. One person asked, do unions make sense for small workplaces? Another asked, is there a recommended minimum number of employees when starting a separate union? For example, what if there are under 10 employees at an organization who may not all join? How would the pros and cons look in this context? And then someone else asked, at what point should we be considering unionizing? For example, a small online pop-up shop with one person doing everything doesn't need to unionize so much, but at what point in the growth process is a good time to seriously look into it? So do you want to speak a little bit about size and how that?
Sure, John, I'll take that. And if you want, maybe the what's a good time probably is more a question you can answer. But in terms of size, you can have a bargaining unit of 2 or more. So, because you have to be able to collectively bargain. Collectively is 2 or more. So I've got, I represent companies that have 3, 4, 5 employees. So I don't know from that perspective if the size of the company is necessarily determinative of whether or not unionization is right for that particular store or company. As much as other circumstances like the ones that John and I both mentioned of the wages and benefits and time off and the dignity and respect and working conditions. So I think from a size perspective, legally it's 2 or more. Practically, it's really very much case by case.
And I would just say the timing is really case by case as well. Sometimes a store or an employer has been operating on a non-union basis for years or decades, and then circumstances change. It may be that external circumstances change, or it may be internal circumstances change. It may be a change in personnel. It may have nothing to do with personnel, but whatever the reasons, that can change. And so even after years of not being union, the employees decide they would actually like to have a union after all. In other cases, it can happen it happens very early on in the process, or with a relatively new employer, where employees are there who want to have say and have influence and be organized to be able to give that influence in a somewhat more consistent, organized kind of way. And so they organize early on. So there really is there's no hard and fast on that issue either.
Interesting. Another kind of grouping of questions is around the unit and talking about distinction between management and worker. When is a supervisor considered management? When would they maybe fall into the worker category? Some of the questions are, is there a legal distinction? Well, this is somewhat related. Is there a legal distinction between the restrictions on supervisors and the restrictions on ownership and navigating unionization, i.e. stores where the owner is also the manager? But there's also a question about the library world. Department heads who are supervisors can belong to unions, but they're in a different class. How would that translate to retail book selling? How is supervisor defined? So maybe you could speak a little bit to that.
I'll say a couple of things and then turn over to you, Mark.
Sure.
First of all, if by libraries you're talking about public libraries, there are many public sector labor laws where supervisors actually do have the right to unionize. So it would not be surprising if you were talking about a public sector library, depending on the state, for the supervisors to have their own union. Often they will be in a different unit from the non-supervisory employees, but not always. That can vary as well. In the bookstores, in the private sector, by law, employers have the right to keep supervisors out, because, to go to another one of your questions there, supervisors are agents of the employer, of the owner, of the employer. So the restrictions on them apply to the supervisors, just like with Mark's examples of in an election, in a union campaign, when the employer can't threaten or interrogate, that applies to the supervisors as well. They are agents of the employer. However, as the questioner obviously has in mind, there are supervisors and there are supervisors. Technically, the definition is a fairly complicated one. It's sort of an 8-part test of having, if you have the authority to hire, to fire, to promote, to reward, to assign work, to direct work, to lay off, to suspend, or 8 more tests to effectively recommend any of those. If you have any one of those authorities, you are technically a supervisor. But as you can imagine, the difference between being a lead person and a supervisor can get very borderline. And so often what the parties try to do when they're trying to work out an agreement about the unit voluntarily is, they'll kind of take into account who's really a supervisor and an agent of the employer and who's more of a lead person and should be in the union, can be in the union. And often they'll work it out. One advantage of voluntary recognition is that there can be, some sort of trade-offs where the union has its desires about who it wants in, the employer has its desires who it wants out, and there can be a little bit of more flexibility around that than there would be at the NLRB. But technically, the supervisors, the employer has the right to keep the supervisors out, although it's not illegal to have supervisors in. So if the union and the employer are okay with the supervisors being in the union, in the unit, that happens. Mark, what have I left out there?
Yeah, very, very little, John, but a couple of things I'll add to that. It is not illegal. It is, at least in my experience, uncommon. But one of the things that I think is most important about what John said is it's not really what you call somebody. You can call anybody a supervisor. It's kind of whether or not they actually do any of those, all of those 8 tasks that John described. I mean, I go through this all the time where, during this process, employers try to convince me everybody's a supervisor. They have no hourly employees and all supervisors. And I have to spend the time counseling them that, no, they have to be able to hire, fire, recommend, and all the stuff that John listed. Secondly, just to expand on one other point, people who would be in the equivalent of a lead position typically would be in the bargaining unit, right? So they are usually people who have, just to keep it simple, I guess, more responsibility than, say, the worker in their position, but not the responsibilities that John laid out for a supervisor. So typically, because they don't meet that supervisor test, somebody who has a lead type designation is typically in the bargaining unit. So that's what I would want to add to that.
There's also a category of managers, which I'm sure there are a few in some of the larger bookstores, where they may not supervise any individuals, but they have a very direct role in formulating and implementing major company policy. If that's the case, they can be excluded as managers. But there too, it can get very borderline. And there's some that are very obviously, there's usually one or two who are very obviously managers, whether they supervise people or not. And then there are others who the employers often say, well, they manage, and to some very limited degree, they may implement policy and so on, but on a low level, and they would often be included. But there too, there'd be flexibility if the parties are sitting down and trying to figure out what's the right unit.
Great, thank you. Joy, you want to jump in?
Yep. So here's another one. Is there a reason to unionize when relationships between staff and ownership are already positive? Or do you find unions most useful when employees feel dissatisfied? In other words, what are the benefits of unions to happy staffs?
I'll start that one, and I'll let John take it from there. I would argue, just in sort of thinking through that question, there are advantages when it's a happy staff and reasons to join a union when there's a happy staff, right? It's clearly more common when it's an unhappy staff, but I think it's worthwhile in certain circumstances. One of the things that John and I spoke about or touched upon throughout the presentation is you have to be a little careful. The time that we have today sort of maybe causes us to be a little overly general in this conversation, but this is really very store/company dependent. It depends on the circumstances, but for the reasons we mentioned earlier, whether it's the standardization of terms, whether it's happy but you want sort of a more streamlined grievance process, more of a say in things like policies and benefits. I've been involved in many negotiations where it wasn't necessarily a horrible fight that got there, although again I would stress that is more common, and I would think John would say the same thing, but certainly there is a place for it in a happy environment as well.
Yeah, I completely agree. I don't have to spend more time on this. I'll just say that the ones you read about in the newspaper, the Amazons and the Starbucks and so on, they're commonly ones where things have gotten to a pretty contentious relationship between the employees, the staffs, and the employers. But there are plenty of cases where they don't make the newspapers or the media, but where the relationship is very good. And just like that example I gave at the very beginning with the Democratic National Committee and the union telling them right from the outset, people actually like you and they like the supervisors. They just want to bargain for better promotional opportunities and career ladder system. So it's both, and it should be. If you think of the main value of a union as having workers having voice, then that should be a value, whether the relationship with the employer is a good one or a more difficult one.
This next question is kind of related in some ways. This person mentions that you both talked a little bit about desiring respect and dignity. I touched on that as well. This person comments that traditionally employers haven't necessarily liked unions in their opinion. How exactly does unionizing give employees respect and dignity?
Well, John, yeah.
Well, I mean, I think, that's why, to me, I prefer calling it worker voice, because in many cases, you'll have workers who want to have a union, even if they already do feel they have dignity and respect. It's a way of giving them, more input, more ability to have a better organized way of communicating their views about different aspects of the employment relationship. But to some degree, that does affect dignity and respect. And of course, there are plenty of scenarios where the employers are treating employees very arbitrarily, very capriciously, and very discriminatorily. And in those cases, when that's what motivates employees to organize, that a lot of that does have to do with dignity and respect. These days, discrimination, equity and inclusion issues are very high on workers' lists in a lot of workplaces. Sexual harassment issues are very high. In many cases, there has been a feeling in many workplaces that they haven't been able to get those issues elevated up enough, and those are very core dignity and respect issues. So it varies, but I think really the bottom line is that what people mean by dignity and respect is the ability to have a more equitable relationship with the employer and be able to sit at the table and, through their own representatives, be able to share their views more officially and more efficiently on whatever the concerns are at the time.
Just to quickly add it, and I think at the beginning of the presentation, John said people may be surprised at how aligned we are in our thinking. So I will reiterate that before just also adding that I think the word voice is the right one, because I think sometimes we could jump right to the conclusion that the only way employees can get dignity and respect is by having a union. And for those stores or companies that treat their employees really well and pay really well, that's not necessarily always the answer. But to have a voice is to me, I think, the right word. I have wonderfully good relationships with most of the unions I've represented in my careers. I mean, there are times on both sides, certainly. I've been very difficult clients, but I've also had difficult union representatives, and sometimes, that's the dignity and respect issue gets a little bit muddled in that arena too. So the bottom line is voice is the main reason. And I think it's a very good reason to unionize. And I think it's probably a better term to use than dignity and respect for the reasons that John gave, and I just added to it.
And here's another one that's interesting. In regards to flexible contracts and diversity issues, do you have any thoughts about ensuring reasonable accommodations for disabled and neurodiverse employees within union contracts? Finding the balance of individual needs and group contracts sounds like it could be just a singular line mentioning that, but would love to know if you've all had history with that. One of the on issues where there is public legislation, or there is legislation that applies across the board to all employees, whether unionized or not, those individual rights do not go away when employees vote to have a union. And one of the best examples of that, Fair Labor Standards Act is an example of that, the minimum wage or the right to overtime, after 40 hours. Same with Title VII and discrimination issues, and the ADA, Disabilities Act protections. Those don't go away. Often unions and employers do not include extensive language on discrimination or on, the right to any more than on the right to overtime or whatever, because the minimum standard still applies. But at the same time, there are often the reason why unions do, so they may not get into the details of what their statutory rights are for reasonable accommodation, but those rights are still there. Sometimes they will adapt
the statutory rights to a particular workplace, or they'll go beyond, or they'll go into more detail. And then that does get included in contracts. And whether there is more or not to what they bargain, often there's a much more efficient and inexpensive way to resolve disputes when they come up around discrimination or reasonable accommodation, because they can go to the same grievance procedure that applies to, vacation pay or whatever, and deal with it rather than having to file a Title VII case in court. They can try to resolve these issues in their own voluntary grievance procedures, and so on. Mark, what else?
Yeah, just to add to that, I think part of the question was also about, issues that might affect a single person or a small number of people. And I would say that is very common in union contracts to negotiate provisions that might provide for a top of the leaves that John mentioned. It could be a military leave. It could be a personal leave. It could be any leave for union business. Any one of those at any one time could affect nobody. Could affect one person out on a military leave. Could affect one person who's requested a personal leave, and that permeates throughout a contract. I mean, you have certain contracts that provide for bereavement time, and there's only one person out maybe every so often who unfortunately has a death in the family. So on top of what John said to the person or persons who asked the question, carving out contract provisions that might have an impact on one or a small number of people is not only permissible, but common.
Great, thank you. We're down to 2 questions. I'm going to ask real quickly, our bookstore is engaged in contract negotiations right now, and management has offered to bring in a federal mediator. Can you talk a little bit about the pros and cons of using a mediator from the worker's standpoint?
I'll start real quick and I'll let John chime in. So I'm not familiar right now with anyone. That doesn't mean that there aren't any. However, the federal mediation process is one in which the mediator who is appointed or selected by the parties, it's a non-binding process. So typically mediation is invoked, not always, when the parties are at a point in their negotiation process where they're stuck. And the purpose of the mediator, who is a well-seasoned, sometimes former union member, sometimes former resource person, it could come from a different backgrounds, but typically one that's been involved in the labor process. They come in as a fresh voice. They come in as somebody who can talk to the issues that are people are struggling with at the table and perhaps have a unique perspective. However, both sides have to agree to have mediators present, and the mediators' recommendations are not binding on either party, even after they go through the process. As far as the benefits to the individual members, John, if you want to maybe pick up on that one.
Yeah, I mean, from the union's point of view, I think that there can definitely be value under certain circumstances. But to go back to one of Mark's first points, usually that value is there only after the parties have really tried to work it out on their own and not been successful. At that point, it can be very helpful sometimes to have an outside mediator. But the disadvantage is that you are bringing in sort of a third party who is not going to be nearly as familiar with all of the circumstances going on, the pros and the cons, what's important, what's less important. Both sides, he or she relies on both sides to tell them about their priorities and to be as honest as possible. But it's still very difficult. And where the parties, normally they would want to try to work things out on their own, and they wouldn't want to go to a mediator until they're really convinced that they just can't get there without needing an outside person.
That's helpful. We had a question that was sent in ahead of time, and we've touched on this a little bit, but I wanted to make sure we had answered it fully. Kind of the difference between someone starting a new union or joining a newish bookseller union versus joining an established union that might be part of a different industry.
Yeah. I mean, these days, there are, as I said before, there are way more workers trying to organize than there are unions available to help them. In some cases, unions, that traditional unions. I mean, I remember for a long time, restaurant workers were trying to organize, and there is a big union of hotel and restaurant workers, but that union was focusing exclusively on hotel organizing. And so when a restaurant, even if 99% or 100% of the employees wanted a union in their restaurant, often the union would say, sorry, we can't help you. You're going to have to do this on your own or find somebody else to help you, because right now we're focused. We've got limited resources. We're putting them all into the hotels. With the bookstores, I don't think there are any national bookstore unions. There are retail workers unions. I know that the United Food and Commercial Workers has been representing employees in some places. There's a service employees union who represent employees in some bookstores. The unions are not bound to particular sectoral jurisdictions. So they do, go, and sometimes it's for reasons that are as arbitrary as somebody knows somebody at that bookstore. But there are more and more places where not more and more, there are some places where the employees are trying to just, sometimes because they can't find a union that's willing to come in and put resources in and help them, they are organizing their own independent bookstore. I don't think one is definitely better than you can't overgeneralize. Obviously, workers normally would like to have an established union come in and help, because they do have resources. They do have the both money and the expertise and experience that they've gotten from years of doing this. And often employees who are new to unionizing need that kind of help. So I don't think that, as with everything else we've been talking about, there are pros and cons. There are pros and cons to having an established union. But for the most part, it's an advantage where the employees can find a union that they feel is compatible to come in with that kind of help.
Yeah, I don't, that's a perfect answer. And I think maybe the only thing that I would add, which is probably just a bit redundant in and of itself, is, it's like any other process. You have to be comfortable with the union, with their experience in the industry, with the people who are going to be organizing, with the people who might be representing you as, the individuals. So there is a certain, there's a certain expertise element, and then there's you have to be comfortable with the people that you're going to be working with, because past organizing, this is also going to be the union that's going to be representing you going forward. So there has to be a certain comfort level as well. But that's all I need to add.
Well, we have gone over, as I knew we would, and you both were right. This could go on and on, but we have to keep somewhat to a schedule. I am going to, we're in our post-event survey, so all of you who are here, we're going to ask if you want follow-up sessions. Mark and Jon have volunteered to do that, and so please weigh in if you are. And Jon and Mark, thank you so much.
Very welcome.
I think you answered all the questions that we got, and we really appreciate all the work you've done ahead of time and talking with Allison and me. So thank you.
Thanks for having us.
A pleasure, especially to do for as righteous a sector as the bookstore sector.
Thank you.
We appreciate that.
We really do.
I should say the independent bookstore sector.
Right?
Thank you. We appreciate that even more.
Yeah.
All right. Thanks, everyone.
Okay.
Take
care.
Bye.
Thanks, everybody.
Thank you for listening to Booked, the Bookstore Education Podcast brought to you by the American Booksellers Association. Don't forget to subscribe to the show on your favorite podcast app. Additional educational resources can always be found on the ABA website at www.bookweb.org. Happy reading!